Hi, welcome to the fourth session in our webinar series on reform of the ABA Model Procurement Code. Today, we'll be discussing cybersecurity in state and local procurement. Full information on this webinar series is available at publicprocurementinternational.com. My name is Chris Eukins. I'm a professor in the Government Procurement Law program at George Washington University Law School in Washington, D.C. Our opening session of this series last week gave an introduction to the Model Procurement Code, and we discussed potential areas of reform to the code which hasn't been updated since the year 2000. In the second session last week, Scott Scheffler of the Felsman Tucker firm in Washington, D.C. discussed Office of Management and Budget, or OMB, grants guidance in detail as it relates to procurement. The OMB grants guidance directs grantees on how they should be, what they should be doing, what requirements they should follow as they're procuring using federal grants funds. Like the other recordings of this series, the recording of Scott's presentation is on the program page of publicprocurementinternational.com and on the GW Law Government Procurement Law Program YouTube page. As I said, the OMB grants guidance directs federal grantees on how they should conduct procurement using federal grants funds. Historically, a core role of the Model Procurement Code has been as a model for federal grantees. If they followed the Model Procurement Code when they procured, they could be confident that they complied with the federal government's guidance for grantees. That's no longer true, as the OMB grants guidance has been substantially overhauled since the Model Procurement Code was most recently updated in 2000. The reform of the Model Procurement Code will therefore likely focus first on bringing the Model Procurement Code up to date with the OMB grants guidance. Earlier this week, on Tuesday evening, we discussed the next step in the analysis, a gap analysis on what needs to be reformed in the MPC to conform it to the Office of Management and Budget's grants guidance. We were joined again by Scott Scheffler, by Keith McCook, who's been a leader in the MPC reform effort and has extensive experience in South Carolina state procurement, and by Yolanda Williams, whose paper at GW Law School formed the foundation for Tuesday's presentation. That third session was an excellent opportunity to discuss some of the challenges we'll face if the MPC is to be brought into conformance with the OMB grants guidance. Tonight, in our last session, we'll be stepping beyond the strict terms of the OMB grants guidance. The current OMB grants guidance calls in section 200.303 for grantees to have internal controls in place to protect confidential information, but the OMB guidance does not impose specific requirements regarding cybersecurity. I should just notice as an aside that, as Scott Scheffler mentioned during session 2, OMB has informally announced that it may soon revise the OMB guidance. So it's possible that relatively soon the OMB guidance will specifically address cybersecurity requirements. State and local governments are going further than the current OMB guidance, though, in imposing demanding cybersecurity requirements when they purchase information technology. Our speakers this evening will discuss these emerging requirements. During the first hour, GW students Brendan Hancock and Jacob Berkowitz will discuss different strategies that state and local governments are using to ensure cybersecurity when they're procuring. Brendan Hancock is a third-year law student at the George Washington University Law School, concentrating in cybersecurity and government procurement law. He is GW Law's 2022-2023 Coalition for Government Procurement Scholar, editor-in-chief of the Federal Circuit Bar Journal, and a vice chairperson for the ABA Public Contract Law Section's Battle Space and Contingency Procurements Committee. Before enrolling in law school, Brandon was a military intelligence professional and a Chinese Mandarin linguist in the U.S. Army. Jacob Berkowitz is a rising 2L at the George Washington University Law School, currently interning at the Department of Homeland Security's Office of the Principal Legal Advisor. He is a member of the Public Contracts Law Journal and treasurer of the Government Contract Students Association. While pursuing a concentration in government procurement, he is also interested in national security and international law. In the second hour, we'll be joined by Jessica Kashri of StateRAMP, which helps shape cybersecurity solutions for state and local governments. Jessica is the Government Engagement Director at StateRAMP. StateRAMP's mission is to promote cybersecurity best practices through education, advocacy, and policy development to support its members and improve the cyber posture of state and local governments and the citizens they serve. This standardized approach by StateRAMP allows providers serving state and local governments to verify their security posture and prove their cybersecurity compliance to their government clients. Jessica furthers this mission by providing implementation and training support to all levels of government. StateRAMP combines best practices and shared services to enable an efficient path for security and procurement teams to incorporate StateRAMP into their cloud supplier risk programs. We'll go for about an hour this evening and with Brandon and Jacob, and then we'll take a break and finish up at about 8 p.m. And with that, gentlemen, I'm going to go ahead and bring in our slides. And just quickly want to note that we do have a Q&A function running. So if the members of the audience have questions, please feel free to put them on Q&A. And just to emphasize that all speaker statements are in their personal capacities. This evening, if you're interested in our program at GW, please feel free to go to GW Beyond the FAR. That's a program website for the GW Law Government Procurement Law program. And Brandon, I'll turn it over to you.
Yeah, thank you for Professor Eukins for your introduction. And so Jacob and I are going to be talking about what's happening in cybersecurity when it comes to statutes, requirements, standards, and contract provisions, both at the federal and state level. And one of the reasons why we want to cover the federal level is just to get an overview of what's happening there, because it kind of tends to lead where we're going at the state level and sets an example. And another reason is, as you mentioned, we're trying to align the MPC in its revision with federal guidelines. And so we want to match that up as possible. And we want to keep standards as less invasive and obstructive as possible. So that's kind of what we're doing tonight. And so we want to go ahead and get started just with talking about what cybersecurity is. And if you don't mind moving forward. So we talk about cybersecurity, but it means really a bunch of different things. And when we talk about it in contracting and at the federal level, we're really mostly talking about information security. That's what's most sensitive and the easiest to kind of get out of control. And so information security started at the federal level, protecting it specifically when it came to unclassified information, really post 2001, post 9/11 in that era. And so at that time, the federal government passed the Federal Information Security Management Act of 2002. And that essentially said the federal government has information that's unclassified that still needs protected, especially when we move into this era of counterterrorism. We don't want everything going out to just anyone. We want to make sure that it stays secure. And so at that time, federal government said you need to start protecting that information, especially if it's digital, and they gave very minimal guidance on how to do that. And then you also have system security. So information security goes to the actual information that's being shared, whether it's some sort of law enforcement sensitive information for official use only. There's consumer information, private health information, all of that just goes into that information security portion that we're trying to protect. So system security is the actual protecting a lot of the architecture that we have our systems built around, and that goes into the communication technology is really what that is relating to. And then you have operational security. Operational security goes to protecting operational technology. So those are things that keep processes automated. So say you're in a factory and it's mostly running off of programming. The operation technology is the stuff that's running that programming for manufacturing, but also it could be a different industry. And you also have, thinking about operational security, when it comes to critical infrastructure, that's where a lot of things get tied into cybersecurity. We're talking about making sure that we have, for example, when the Colonial Pipeline hack happened, making sure that we're still able to run through our major infrastructure, whether it's oil and gas like that incident was, or there's a new statute that just came out last year that talks about securing our water supplies at the local level and providing cybersecurity to public utilities in order to do that. And then wrapping this back around to the information, there's a lot of confusion between privacy and cybersecurity. So privacy is really what you're doing with information once you have it. But the cybersecurity side and the information security side is really making sure that that information is only accessible, especially technology-wise, to certain people. When you talk about cybersecurity too, the federal government has started breaking it down into these three main points of confidentiality, availability, and integrity. And so confidentiality is just making sure that it's not being seen by anyone who doesn't need to see it. It's kind of that need to know type concept. And then you also have integrity. So that's making sure that the information that's posted, you know where it's from, and that it's you can have trust that that information is accurate. And then the availability of information is precisely that, just being able to access your information. This is what really gets affected when you have a ransomware attack and you can't access any of your data. It's a lack of availability. And so all of those go into information security, which all falls under this idea of cybersecurity.
So Brandon, before we go on, can I ask a quick question? So when we've had a number of students over the years who've written comparisons looking at European approaches to cybersecurity and procurement, comparing it to the US approach. And what's really come out is that the Europeans put first emphasis on privacy, on the privacy of their citizens, as opposed to information security, system security, operational security. Do you think in your estimation, because you've been working with cybersecurity for a while, is the current contractual structure the way that the federal government is going? Does that take adequate account of issues of personal privacy?
I think it does. So personal privacy also gets covered with other statutes. And what's really incorporated into federal contracts is more of the information security. There's more of a focus on the actual systems when it comes to the standards. It's a lot more of just making sure that once information hits your system, it's going to be protected. It's not necessarily looking at specific types of information. However, there is also another issue at the federal level with actually marking information that's unclassified but still needs certain protections. And so there's a lot of stuff that still gets missed by pushing it through that way. But going back to the idea of focusing on privacy as opposed to the actual security, it's something that gets incorporated a lot when you actually look at disinformation and cybersecurity there. And that's much more of a national security threat, and trying to identify the players in that area, or also the financial sector, making sure or checking in on who's making those financial transactions. Those, I think, are areas where that privacy aspect is more applicable than when it comes to contracting. And so we'll go ahead and get started with the actual standards that first act that I talked about actually implemented. So what happened was, like I mentioned, after the Federal Information Security Management Act of 2002 got passed, all the agencies started just putting out all these different requirements and putting out all these different markings on different documents. Like I said, there was law enforcement sensitive information, which was unclassified, but still got protected in certain ways. For official use only was one that I saw so many times when I was in the military, just all over the place. And it ended up getting to where there was over 100 of these different markings on things, and nobody knew what to do with each specific one because there were just so many different ones that were coming out. And so by presidential memorandum, the executive branch set up this CUI program. And so CUI is controlled unclassified information. It's different categories of information that we still want protected, but we also aren't classifying because it doesn't have that much effect on our national security, at least on its own, but still needs to make sure that we're not just releasing it to anyone. It still needs to stay secure. Like I mentioned, a lot of that is related to either personal finance information, consumer information. It could also be the Department of Homeland Security has their own categories, especially when it comes to critical infrastructure. So there's a whole category just of critical infrastructure information and how to handle that. And that all gets outlined now. That presidential memorandum got transferred over to an executive order, and the executive order got transferred into the Code of Federal Regulations in part 2002 of 32 CFR as the CUI program. And so some of the issues that come into how you deal with this particular type of controls in cybersecurity is, first of all, identifying the information that you need to protect. And so that goes back to the issue that I just mentioned, is the federal government is still figuring out what information and where it needs to be marked in order to remain protected down the line, especially when it comes to federal contracts. We find, looking at the Defense Department, there's a lot of stuff that doesn't get marked that's supposed to be, that's covered information, but it still gets passed down to the contractor without any of those caveats attached to it. The other part that's really important to CUI is the handling of information. So that could be just making sure that it doesn't get in the hands of someone who's not supposed to have it. If it's a physical copy, making sure that it's not being passed around in office if someone doesn't have a need to know that information. That's where a lot of times it gets mishandled, and mishandling of covered unclassified information is actually one of the ways that it's being sorry, I lost my thought for a second. But we'll keep going with talking about information systems requirements. The controlled unclassified information, covered unclassified information program draws on a bunch of different sources really for what the system requirements are, but the baselines are defined as adequate security. And so for federal systems, it says that adequate security essentially implements all the security measures in NIST special publication 800-53, which goes over the protection of federal information and federal information systems. And then there's a non-federal equivalent to that, which is NIST special publication 800-171. And that one's undergone, it just had its most recent revision put out within the last few months. And there's also been implementation guides that have been drafted and published in the last few years, explaining how to really use those controls that are in those guides to secure your system.
Can I just ask a quick question here, Brian? So the state ramp uses the NIST standard 800-53.
Yep.
And so does that put state ramp, which we'll be discussing in the second hour, does that mean that the state and local governments are essentially applying that, if they're following state ramp, that they're applying the same standards that a federal agency would apply?
So it depends on how they're doing their assessments, and I'll get to this in a minute, because assessments are one of the huge variables when it comes to actually applying these standards and making sure that they're implemented properly. But the requirements are the same. The NIST 800-53, it's almost 500 pages long and has a bunch of different controls that aren't going to be applicable to every system. And so I won't say that the actual implementation is the same at the federal level as it is at the state level if they're going with that document, but they're at least referencing the same thing and hopefully coming up with the same conclusions, especially when it comes to overarching what are things we need to do. So whether that has to do with validating credentials, or if it has to do with setting up your systems so it has segregation built in, so you're only having access to what you need to do your job, and some of those controls, those are all in 800-53. And so the federal acquisition regulation actually does have a provision and a clause that associates with controlled unclassified information, and it really just comes down to the clause, and the clause says that there's specific measures that you have to take to protect controlled unclassified information. And those are simple things as far as just making sure if you have controlled unclassified information that it gets destroyed once you no longer need it, making sure that you're not passing it along to someone who doesn't need it, and making sure that you have multi-factor authentication turned on your systems to make sure that those stay secure and no one is using stolen credentials to access systems, because that's the primary way that systems are actually being infiltrated right now, is through authentic credentials that get compromised. And then you also have within the CUI program, some federal agencies are putting in specific CUI provisions into their FAR supplements. So for example, the most robust one, I would say, is the DoD. They have the clause 252-204-7012, which says apply NIST 800-171. And then you also have a series of other clauses where it says, now you have to go into our computer system and actually put in an assessment score that you've done on your own system to verify that you're implementing this program and we know how secure it is, so we can evaluate that risk when we make our contracting decision. The next step in that process is the CMMC program, so the Cybersecurity Maturity Model Certification Program, which is in the last stages of rulemaking, and DoD has kind of paused putting out any additional information on that program as they await the rulemaking process. So it's been talked about quite a bit over the last year and a half when it got put on pause, so I won't spend too much time on it. But then you also have, for example, the Department of Energy, which really avoids mentioning any specific standards at all. So whereas the CY program earlier, like I mentioned, it specifically lists out NIST SP 800-171 for non-federal systems. The Department of Energy completely avoids that whatsoever. And they say, if you are included in critical infrastructure, which most of our contractors are, because energy is encompassed by one of those industries that are critical infrastructure. They say that basically you apply what you need to according to statute and regulation, and we'll provide some guidance for you to do assessments and to kind of explain what the standards are, but we don't refer to any specific set of standards in our contract clauses. And so one of the issues that has really come up with the CY program is this idea of assessing and validating contractors, and even agencies themselves. So there was a report, I think it was done by the GAO, that found DoD had been required to do off of NIST SP 800-53, and essentially nowhere across the DoD were they fully compliant with that document. And they found the same thing for these contractors who are trying to implement NIST SP 800-171 after the DoD first rolled out that clause. And what the DoD has been finding, basically they'll go in to walk a contractor through an assessment. They'll look at what the contractor had already reported their scores to be for their self-assessment, compare it to the new assessment, and none of them were matching up. Basically, all the contractors were inflating their scores, and it's mostly because NIST publications are written in a way that they're meant to be generally applicable. And so if me as a contractor interpret it a certain way and think that I'm complying with it, and more experienced IT professional who's doing just these assessments all the time comes in and looks at what I'm doing, it's easier for them to find something as insufficient or inadequate, even if I think it's good enough. So there's this big disconnect right now between assessments and actually seeing the implementation of these documents and standards.
So the couple questions I want to ask that go to the strenuousness of these self-validations. So the first one is the question regarding whether or not cybersecurity should be an evaluation criterion. A few years ago, the Defense Science Board recommended in a report called Deliver Uncompromised that cybersecurity be an evaluation factor. If you have good cybersecurity, you get evaluated better. If you have bad cybersecurity, as opposed to making it a yes/no question, probably lodged within responsibility, within qualification. So, Brandon, do you think that the cybersecurity maturity assessments are sufficiently mature themselves so that we could actually start using cybersecurity, or how cybersecure you are as a contractor, as an effective evaluation criterion?
I think that's a difficult question. So when it comes to evaluation, that's also kind of how this started. And there's still recommendations that if a particular contract needs higher standards for cybersecurity based on the information that's going to be in the contract, that they include that in the solicitation, as well as mention that in the evaluation criteria. I don't think the issue of the interpretation of the compliance really matters either way, if you're looking at it through the technical evaluation or as the just a yes or no, check the box, as if it were, part of responsibility determination. And one of the issues that led to the certification process was that it was supposed to be incumbent upon the contracting officer to check and make sure that whoever the awardee was would be compliant at the time of award and then throughout contract performance. And essentially, contracting officers don't have the expertise to be checking up on that. Essentially, they'll just look and make that determination of yes or no, check the box. Do they at least say that they comply with the NIST document? So I think there's a possibility, if it's part of the technical evaluation, that there's room for the solicitation to say more specifically, how are you adopting or implementing these specific controls? And so if that's what the contract needs to protect a higher level of information, then I think it's useful there. But I also think that depending on what level it is, just saying, yes, we have adequate cybersecurity, and then accepting that liability in case something does happen. So one of the things that's also happening at the state level is they're passing affirmative defense laws when it comes to cybersecurity. And so it says, if you implement or adopt the standards of a known cybersecurity program, such as NIST or one of the ISO standards, FedRAMP, there's a couple other ones that get mentioned quite a bit. And it says, if you adopt one of those, you are no longer, you have an affirmative defense for whatever damages might come from tort liability through a breach. And so I think when you're saying as part of the evaluation criteria or using it as a contract clause, the yes or no, just do you have cybersecurity, you're passing that liability onto a contractor and putting it on them. So I think it depends on how you go about enforcement and the needs of the actual contract that the solicitation is for.
So that, because I think you answered my second question, which is there's been a lot of work in the federal government to impose fraud liability in the False Claims Act for not having adequate cybersecurity in place. And the Supreme Court's recent decision in Justice Thomas's decision, the super value case, made clear that the standard for that, for civil liability, is a recklessness standard, is the contractor proceeding in the face of a known risk. That's a very difficult standard to apply in cybersecurity because the risk by definition is unseen and unseeable. And so really the question is, how much is the contractor investing in cybersecurity? What's implied in that is on a contractor's ability to confirm with the contracting officer that the contractor is investing the right amount in cybersecurity. But I think he just told me that the contracting officers can't really respond to that. So there isn't really a dialogue between the contractor and the contracting officer about what the right level of investment is. Is that fair?
Yeah, well, part of the problem too is that they're trying to set up this system so it keeps costs as low as possible for implementing cybersecurity measures, but at least for the CMMC process, the costs are a lot for cybersecurity for cybersecurity assessments because of the process that they have to go through. So they essentially find a third-party vendor who's been certified, accredited to do the certification assessments. So they find them, they have to go through a long assessment process to say whether or not they're even at the standard, depending on what the level is. They then also have to verify through DoD, the DIBCAC, that they also think that this contractor is matching the standard. And then finally, they get their certification and are eligible for contracts. So they're somewhat simplifying that process. And I think as cybersecurity has become more and more of an issue, that the cost of cybersecurity is actually going down long term as contractors continue to upgrade their systems and adopt both hardware and software that are more secure than they were before. So that stuff is already being built in. And one of the other things too is that cybersecurity related costs are allowable. So the contractor also has the ability to pass that on in their contract. So in addition to CMMC, one of the other programs that is run by the federal government is this FedRAMP program. It's the Federal Risk Assessment Management Program, and it all has to do with cloud services, cloud-based services. And so cloud-based services are basically anything that you're doing information systems wise, so computer wise, but it's not being done locally. So if you're running an application, like say Office 365 has all of their Microsoft Word and PowerPoint and all those applications that you can just work off of online. When you're doing that, it's actually considered cloud-based. And so they can do everything from set up a virtual machine for you. So you open up this program, it's like a whole nother computer shows up on your screen, and you're doing everything like you would in a normal computer, but it's all based somewhere on some distant server that's all being sent through the internet, done through the cloud. And so this is kind of showing all those different elements. So you have what commonly gets thought of as cloud-based services is just storage, just being able to save your stuff like in Google Drive or in one of those systems, all the way to the processing and even all the mobile applications, all that stuff that gets interconnected, that you're able to switch from one device and then go back to where you were on a different device. All that cloud-based stuff is what goes into this. So as it says right here, there's 313 currently authorized services that have been through the FedRAMP process, which has been around since about 2010. And since this program was started, the federal government has actually set up and codified a prioritization for cloud-based services when it comes to what's offered there. And one of the reasons that that's important is because it's a more efficient solution for the government, because they're no longer having to get all the hardware and software that they would need to adopt within their own offices and equipment to make sure that they're able to, operate these big, 1,000 of people departments, and make it quick enough that they're able to actually stay up on all the federal programs that get through the departments. And so it's also more efficient because it's a pay-based system, so you only pay for what you use. So not only are you saving money when it comes to not having to replace hardware and software, because that's all provided for you, but you're only using as much as or paying for as much as you use. And so how the process works is a cloud-based provider will go to the agency that they're looking to contract with, and they get paired up with this process. That initiating agency will walk them through getting an assessment from a third party. And then eventually it gets ran through GSA. They will do their own validation of that assessment and then release a authorization to operate to that system. And then it gets put in the marketplace for FedRAMP. And so that certification is good for 3 years. One of the things that's really important about this program is it's got a requirement that the CUI program does not, as far as continuous monitoring of your system. And that's done both at the CSP level and at the government level. They're looking to make sure that everything doesn't get compromised.
So just to clarify, the CSP is a cloud service provider.
Correct, yes. And one of the other things that's important about this is not only do you have the actual contract that you're entering into, but they're also accompanied by a service level agreement. And the service level agreement is really what defines, the service, but it also provides the measurements for how are you going to figure out whether or not you're meeting performance measures. And so that all gets laid out separately in a separate document.
Although it's 313 authorized services, this is still potentially significant barrier to entry in the federal IT market, isn't it, Brandon?
Yeah, I mean, at a minimum, your service has to be cloud-based, which isn't very common unless you're one of the big tech companies right now. And that's who you mostly see in the FedRAMP marketplace. So I would say that is one of the issues. It'll be interesting to see, especially now that there's a lot of other requirements with requiring that software be built with security in mind and some of those other things, whether they'll expand this program to do some more assessments through this that maybe aren't cloud-based, or try to incorporate that some way, or if they're going to set up a whole different certification system. So part of this development of getting everybody up to speed on cybersecurity is to do that at the state and local level. That's a priority for the federal government as well. They want to make sure that state and local governments are secure because they're processing a lot of federal information. And a lot of that federal information is getting sent through grants. This is a specific grant program, but for example, a lot of the Medicaid and Medicare programs are administered by the states. A lot of like even postal services, all of their stuff is localized. So a lot of that stuff is getting local contracts and agreements. And so it kind of spreads out all over the place. And as you talked about earlier, Professor Eukins, with the OMB guidance, there is a very minimal reference to information security in that document. And it just says that there should be reasonable measures taken to prevent or protect information. And that's a very vague statement, reasonable measures. But it goes back to what we were talking about earlier. Well, how do you assess that? And one of the things is you look at the cost of what the control measures are to the contractor, but also, what is the difficulty of implementing that? And then what is the benefit that comes from that cost if it balances out or if the benefit's higher? So that's really where you're looking to figure out whether or not those measures are worth it. And so you have an example here just showing kind of what's happening at the state and local level. There's been a bunch of different hacks, a bunch of different, ransomware attacks and just breaches. And so one that happened was at the DC Police Department. They had a breach, and it was a ransomware attack. It froze up several of their very significant important systems, and the ransomware developers essentially demanded some millions of dollars and froze up the police system. And one of the things that came out of that was they sent the report to the FBI like you're supposed to when there's some sort of cyber incident, and then the FBI investigates it and shares the information with anybody who might be compromised in that attack. But in that investigation, they realized that a lot of these cybersecurity vulnerabilities come from outdated hardware and software that a lot of state and local governments are running because they essentially don't have funds to update it. And so that's why they rolled out the state and local government cybersecurity grant program. And so there's two main parts of this grant program for states. It's to develop a cybersecurity plan commission, and then they're supposed to develop a state cybersecurity plan. And so they also provide a template for the plan, but it doesn't really talk about acquisitions in there much. Some of the plans that I've seen talk about third-party risks when it comes to cybersecurity at the state and local level, but they haven't really talked about making sure that in acquisitions that you're getting both authentic products and supplies. So there was actually a DOJ prosecution within the last couple of years that was, I think 5 different agencies ended up getting involved, including GSA, because they were selling fake network products to the federal government. And so you have that aspect of it, just making sure you're getting secure software and hardware, and then also making sure that it's going to be compatible across systems and integrated.
All right, I'll just step in. We're going to be looking at procurement codes and how they deal with cybersecurity. I'm going to look at first an older statute from Connecticut and then a new regulation coming from New Jersey. Connecticut, within the procurement code, they create a division of information technology within their Department of Administrative Services, and it's appointed by the Chief Information Officer, CIO. This position pops up a lot when you're talking about IT departments, and the idea behind them is that their goal is to protect what the statute refers to as the public record. It defines the public record as any information that's related to the conduct of a public agency, and it also expands that out into any information that's created or used by the contractor. It has reporting and enforcement provisions within it. So there's mandatory reporting if you believe that there's been a breach, or if there actually has been a breach, you have to report it to the CIO. And from there, they have a process on what to do with the action plan. And then there's also enforcement to penalize companies that do breach this and that don't have adequate measures to protect themselves. Now, the statute's a little older. The last amendment was in 2012. I think the actual it was first enacted in 2009. So at the start of this cybersecurity development. So it doesn't actually mention the word cybersecurity within the statute. It hits all the relevant points within, but it doesn't actually mention cybersecurity as a concept. Instead, it focuses more on this protection of privacy and this protection of the public record. Something like this New Jersey regulation coming from their electronic procurement code for state public schools, it looks at more modern approaches. So it mentions FedRAMP as one of the standards that these electronic procurement vendors that they have to contain, and it has to be FedRAMP certified, or at minimum you utilize something that is similar to FedRAMP. It has more modern applications to security standards, so it uses the NIST password standards as an example. There's the similar concept of the mandatory reporting provisions. This pops up in a lot of regulations and statutes. And the standards here are for the platform itself, not the contractors, but a lot of these concepts within at least the new age of cybersecurity, they are brought up and referenced when dealing with these statutes.
So, Jacob, I know that you and Brandon are working on an article that surveys a lot of different states and how they're approaching issues of cybersecurity. Do you see a trend emerging in terms of how states are dealing with cybersecurity and procurement?
Yeah, so a lot of the procurement codes don't actually reference cybersecurity or a lot of these concepts. Instead, what seems to be the case is that, and I'll talk about this later, there's going to be a Department of Information Technology or its equivalent, and they're going to be the ones responsible for stepping in and enforcing procurement standards, procurement security, or whatever is involved. So here's some examples of statutes within procurement codes themselves. Maryland actually has two. The 4308 is actually the security standard itself. It requires that all contracts have a NIST security within them, or its equivalent. So that's a statute that bakes in these standards within the contract, while leaving the specifics up to the contract itself. 13115 is going back to Brandon's point. A lot of these states don't have the funds to actually upgrade cybersecurity hardware, software. So this one utilizes the government leverage to get a good purchasing power for these devices or software or whatever is necessary to keep the state agencies up to date with the modern technology. The Illinois statute, actually, if you go to the next slide, I have the entire statute on it. That's about it. Prohibited and authorized cybersecurity products. It determines which products are allowed and which products aren't. So the U.S. Department of Homeland Security has these operational directives that can determine whether or not a product, software, hardware is allowed to be purchased by federal governments, and this Illinois statute says if it can't be purchased by them, then we can't purchase it. However, this is the only statute that I found that references state ramp within a procurement code. State ramp, which Jessica will talk about later, is more of a state equivalent of FedRAMP. It's not a binding government body, it's a nonprofit, but what's important here is that it has the same certification process, or at least something similar. So if something's state ramp certified and it's in an authorized product list, and a lot of states use this list as reference for when they purchase their own cloud service providers. The next slide.
A quick question for you, Jacob. The DoD, the Defense Department, allows a contractor vendor to approach DoD and say, look, I don't follow the NIST standards, but let's say I'm from Europe, I'm a Swedish provider. I follow International Standards Organization, ISO cybersecurity standards. And it specifically allows the vendor to approach the CIO and say, look, I have an equivalent standard, I meet an equivalent standard. And there's a lot going on in international trade law with regards to procurement that calls for that kind of openness and standards, that once the government publishes not just a technical standard, but publishes what it's trying to accomplish, vendors can come from the outside and say, look, we can help you accomplish this, even though we don't necessarily follow your domestic standards. Do you see that in state statutes as well, Jacob? A process for reconciling a different standard?
I do. In some of these states, especially in their IT departments, they will state that it's all right if it's not STARAMP or FedRAMP certified, as long as there's an equivalent as long as there's an equivalent certification that roughly matches up to NIST, STARAMP, or whatever process they're using to certify their cybersecurity. So now the focus is going to be on cybersecurity outside of procurement codes. The vast majority of statutes I found don't exist in procurement codes. There's an IT department, it's equivalent, that's led by the CIO, and the CIO is in charge typically of both determining the cybersecurity plan for the entire state, and then determining whether or not contracts are accepted by the state agencies. So this could be from a variety of methods used. Either the contracts have these provisions within them, the CIO has final say on whether or not the contract can even be accepted if they don't like the lack of security that's within, or if it's not to their standards. And it's not within the procurement code, but it's like the final check you have to go through before the contract becomes official. The reason that for this application is that cybersecurity is difficult. It's a lot of people don't understand the standards. Even people that know what they're doing have differing opinions on it. So giving cybersecurity control to someone that knows what they're talking about, like the CIO, makes the process more efficient, and you have this single individual who's allowed to control the cybersecurity standards for the entire state, instead of having each agency have its own standards, and if a vendor wants to move from one agency to the other, having difficulty with that transition.
But you're also talking about there, Jacob, is that in essence you're giving the CIO money control as well. The CIO can control how much money other agencies do or don't spend on cybersecurity.
The CIO does have the ability to deal with that. It depends on the statute and the state itself. Some states have a lot more powers that they give to the CIO, but in general, a lot of these have this no contract allowed if security doesn't go through. So they do have a measure of control over the money in that case. So the next slide has some examples here. So Utah has the creation of a chief information officer, and details what the function of that is. It does include that contract killing clause within. New Mexico has the same thing with its secretary. North Carolina actually has probably the most fleshed out statute that I've seen. It had that entire section 143B, the 1350 is solely dedicated to IT procurement, and this has a clause within about security, in addition to competitive pricing, like the timeline for upgrades and concepts like that. Ohio has the Office of Information Technology within its Department of Administrative Services, similar to Connecticut, and they have similar powers. Oregon actually empowers the Department of Administrative Services to be the IT security professionals. It doesn't create its own separate agency. It just says the Department of Administrative Services is now in charge of IT, and they can appoint a CIO within their own organization instead of creating like the separate hierarchy. Florida actually has some of the best laid out cybersecurity standards. They have a little chart within that's attached to clauses within the regulations. So it's really easy for someone like me who had little knowledge of cybersecurity before coming in to understand what they expect out of contractors and what these standards are for people trying to do business with Florida agencies. So here are just some of the statutes. New Mexico over here has the ability for its CIO to approve information technology contracts and amend these contracts before they get approved by the Department of Finance Administration. So they do have the ability to kill these contracts. And then North Carolina, within one of their sections, compliance with information technology security standards and policies is required as an evaluation criteria for these contracts that they want to put through.
It's just worthwhile mentioning here quickly, Jacob, that what Jessica will be talking with us when in the second hour when she talks about state ramp, one of the functions of state ramp, which you're describing here, is an extraordinary coordination here between the CIO and sometimes the Chief Information Security Officer, the CISO, and the Chief Procurement Officer, the CPO. State ramp helps facilitate that kind of communication across these different offices. It's one of its important functions.
And speaking of state ramp, some states like Texas or Arizona have created their own risk assessment management programs, Tex ramp and AS ramp respectively. They function similar to state ramp, except for the state itself. Texas, as an example, has their 2 levels of security, one for low impact information if it got leaked, and one for medium and high impact information. Both of these have authorized products lists similar to state ramp, where a vendor is able to get themselves certified, get the stamp, and then an agency that's looking for, say, someone to do cloud storage, they can just go to the list and find someone that's been pre-approved, and they can get that process done a lot faster. Both of these programs, however, do accept state ramp and FedRAMP certification in place of a state's process. Arizona, I think, is also a little more lenient in terms of allowing different certifications, but these states have to set up their own authentication processes, which I think Jessica will talk about this, but state ramp being more ubiquitous drives costs down, since these states need to maintain their own authentication while also accepting outside authentication. And as a vendor, it doesn't make that much sense to go to one state when state ramp provides a more open selection process.
Yeah, the state ramp website has some excellent webinars, some excellent videos describing, for example, the coordination between the correlation between the Texas ramp, Tex ramp, and the and state ramp, and how they can be coordinated with one another.
Yep. And California, just I can quickly run through, they have some contract clauses. There's 3 relevant contracts here that I was able to find. They have a general IT provision, and then they have general provisions for software as a service, so any applications that are being utilized, and then infrastructure as a service and platform as a service. Those 2 are combined in their own contract. Infrastructure is the servers or anything that you want to store data on. Platform is, you can think of it more as an operating system, is the best way to describe it. You're not getting an application, you're getting more of a system that you can do things within beyond just a single application. And the next slide has some of the language within these things. So the first one comes from the general IT provisions, where confidentiality of data is a significant part. It requires the specific type of information relating to state's operation that's designated by the state. If it's available to the contractor, they have to keep it secure. And the second clause is looking at the information infrastructure as a service and platform as a service. It's looking at you have to have this data stored within the US. So the second clause, the contract there has significantly more personal data protection, and this is just one example of, they want the servers in the US to keep them both under US jurisdiction, but also to keep the servers not be able to be physically penetrated as easily by foreign entities. So just one example of, this is more of a modern approach to security standards coming from the contracts.
So there's a question for both Jacob and for Brandon. We had a question from Lauren Fleming, who's one of our guests. She said, I'm curious about the effects on small businesses. Is there info on the number of small businesses that have been certified by FedRAMP and or state ramp?
For state ramp, I would have to check the authorized products list, but I remember seeing they do have certification support for small businesses, because they do recognize that the authentication process is the most expensive part of this section. You have to have outsiders come in, go through your systems, ensure compliance. If it's not compliant, you have to upgrade. So I'd have to double check. I think Jessica can definitely answer more about this, but if I remember properly, they do support small business applications.
And Brandon, how's the CMMC been met by the small business community?
Well, I'll talk about FedRAMP because I think that was the question, but I don't know the exact number of businesses that have been FedRAMP certified. I do know that GSA has been working on some GWACs to allow essentially set-asides for, I think Polaris has includes women-owned small business, the other minority-owned hub zone, like all of those set-asides, that's all part of the Polaris contract, and I believe that's all cloud-based. But I don't know the exact number of FedRAMP certified businesses at this point.
Vicky, you want to turn to enforcing cybersecurity?
Yep.
So the first case that we'll talk about, it comes from the federal side. And so the Department of Justice entered into an agreement with Jelly Bean Communications. And it was because Jelly Bean Communications was contracted to design a website and maintain it for the facilitation of children who are seeking health insurance plans through the federal funds, so through Medicaid. And so Florida Healthy Kids Corporation is a nonprofit that administered that program in the state of Florida, and Jelly Bean Communications, starting in 2013, had won a contract to maintain that website for them up until 2020. And so in that contract, it specifically said that Jelly Bean would adapt, modify, and create the necessary code to support the secure communication of data. And basically, as soon as performance started, they were failing to meet that commitment they'd made in that contract. So they had software and security within their IT system that was out of date from the get-go, and they didn't implement any additional security measures to limit access to the applications that were being filtered through. So essentially, you have where it talks about allegedly 500,000 applications being hacked. It's the applications for these children getting health insurance were all essentially made available on the internet because of the lack of security for this particular system. But the reason that this is important on the federal level is because the federal Department of Justice specifically is more attentive to where federal dollars are going, as opposed to whether or not it's a state contractor or a federal contractor. And so that's why DOJ was so focused on this. This agreement with Jelly Bean was, I think it was around 80% of the funds that are being used for that contract were all from the federal level, from the Health and Human Services to go through this program. And so that's why DOJ was really paying attention to it. It falls into their new civil cyber fraud initiative, where they're using False Claims Acts to target federal contractors and grant awardees or recipients who claim to have certain cybersecurity standards that aren't actually being met. And so this is one example of them implementing that against it was a state contract. But like I said, it's more so because the federal funds are being used in that way. There's also some states that have their own False Claims Act, and so it could lead to similar actions on the state level. So for example, Connecticut has their own False Claim Act, and it could essentially lead to the same type of actions on the state and local level as this one done by DOJ.
A second example here of federal enforcement is iHealth Solutions. The HIPAA is the tool that they use to figure out what was going on. What happened was iHealth is a Kentucky-based business associate that they provided coding, billing, and on-site IT services for healthcare providers, which is how HIPAA managed to get in. What occurred was there was an unsecured transfer of information on their servers, and what occurred was this was available for people to find online, and this included stuff like social security numbers, email addresses, diagnoses, treatment information. All this stuff was left unsecured, and because of that, the HIPAA was able to step in and penalize iHealth Solutions for failing to follow proper procedures set out by HIPAA notification rules, and as a result, they ended up having to go through with a corrective program and pay this fine. And this next section, it's not directly related to government contracts, but it serves as a good example as to what reform could look like within the Model Procurement Code. So New York Department of Financial Services, they have a regulation, 23 NYCR Part 500, that goes through a pretty detailed requirement of cybersecurity standards for anyone working within the financial services within New York. So anyone that has a license to practice stuff like banking, lending, anything dealing with finances has to subscribe to these cybersecurity regulations, which makes them pretty ubiquitous. And that's how New York's able to enforce these standards. So the first example, One Main Financial Group, they had to they had to settle with the department for 4.25 million as a result of them failing to manage third-party service risk. So they contracted out themselves to another party, but since that wasn't secure, that violated one of these standards within Part 500. They failed to manage access privileges. People were using the same passwords and usernames as they started with, and they just kind of shared that around, which increased vulnerability as everyone had the same access to similar systems. And they also failed to use formal methodology when assessing cybersecurity risks. So they just used the kind of own in-house process that wasn't as robust, and as a result, it missed all these prior vulnerabilities. And when this leak occurred, that's when the department stepped in and implemented the corrective plan. iMed Vision Care is another example of this. So allegedly, non-public health information was collected after a phishing attack. An email mailbox was able to be accessed by bad actors, and they were able to, I think, go back through about 6 years worth of information, which exposed a lot of people, hundreds of thousands of people, to their information being leaked. And this occurred because no multi-factor authentication was being used. Like Brandon mentioned previously, this is one of the biggest attacks. If you have proper credentials, but you do have multi-factor authentication, then people with your password and email can just get in. They also allowed employees to share credentials. I think 9 people were using the same the mailbox, which just exacerbated the whole issue. And as a result, they had to go through a corrective plan and pay out 4.5 million as a penalty. And just as a conclusion, so cybersecurity issues, as technology is evolving, they're becoming integrated, whether or not it's government contracts, outside of government contracts, everything is becoming more cloud-based, and government contractors and the government itself has to catch up, whether it's state, local, federal. There's still room for improvement. As we can see, breaches still occur at every level, and looking for good examples now is a good way to set up this reform. Certification programs like StateRAMP, FedRAMP, TextRAMP, ASRAMP all exist, and they can help this process along. Having an agency or a company that's dedicated to this type of work means that even if providers don't know cybersecurity standards, they're able to get certified by people who are experts, and by incorporating this into reform, you can make the process easier for those without a lot of knowledge in the field. And cybersecurity approaches from places like NYDFS can be borrowed from its templates, and other more modern regulations from states like New Jersey or Florida can also be utilized.
Thank you both for a really excellent presentation. I think what you guys have done successfully is showed that this is a really complex issue. It's like a three-dimensional chess game. And for the Model Procurement Code drafters, recognizing that there is this complexity, that the different type of statutes that might come into play, cybersecurity might be enforced through different vehicles, even through different agencies within the same state government. It really helps set up not only how the MPC reform process could move forward, but also importantly, what Jessica will be talking about after the break, how the state ramp structure can help bring coherence to what's a very, very complicated process. So Jessica, we're going to take a short break if that's okay. We'll start it at 10 past the hour. Thank you all. See you soon.
Thank you.
Jessica, is it okay with you if I advance the slides? Is that all right?
Yes, that's great.
Thank you very much. And Brandon and Jacob, feel free to type in. So I have been spending a delightful afternoon today going through the State Ramp website and watching lots of webinars that they do, which are really tremendous in terms of background on how State Ramp works. Jessica Kashari, I introduced Jessica before, talking a little bit about the mission of State Ramp. But I do want to emphasize something that we just touched on very briefly. Besides the fact that she's the government engagement director of State Ramp, she really, and this or the director of State Ramp pointed this out in the webinars. Jessica has tremendous background in areas that are directly relevant to what she does. She was the director of professional education at a school of higher education. She also worked in procurement and contract administration in a county government. So she has direct experience in procurement, which is, I have to say, Jessica, it's very rare. It's very nice background to have. She was an attorney in Florida's Department of Children and Families. She has an LLM from American University. Besides her JD at Florida Coastal School of Law, she also has she had a minor in theater at Flagler, which I think is an essential skill for any lawyer. So Jessica, we're so glad you could join us and give us a little background on State Ramp. As you know, the overall purpose of this program, this webinar series, is to lay a foundation for potential reform of the Model Procurement Code. Many of the lawyers and officials and contracts persons who will be involved in that reform process don't have a lot of background in cybersecurity, but it'll be important for them to understand how cybersecurity and State Ramp specifically could fit into a solution of model. That happened the last round. They had cooperative purchasing in 2000, which was really an important part of what NASPO does. Cooperative purchasing really came to the fore in the Model Procurement Code. And I strongly suspect, Jessica, in this round of reform, cybersecurity and solutions like State Ramp will be an important part of how the MPC is reformed. Not necessarily to dictate a specific solution, but to leave the door open to solutions like that. So with that, I'll turn it over to you.
Thank you. Yeah, we would absolutely love to see that. Cybersecurity is so important at this point in our nation's security generally, and we're really dealing with a lot more than we have in the past, because the future of government and technology is that the use and reliance of technology is rapidly increasing. We're seeing a significant level of business that's just being done in a much more technologically advanced way, and you'll see down here that by 2025, over 50% of government agencies are predicted to have modernized their critical core legacy applications to improve resiliency and agility, which is great, but also puts us at risk. Go next slide. So cyber threats are a reality that we simply cannot ignore. What is cybersecurity, right? I know that Jacob and Brandon covered this a little bit, but cybersecurity really are the steps that we take to keep those that we want out. It's locking the doors at night, locking the windows when we leave, turning on your alarm. It's making sure that everybody that has access or entry is trustworthy to have that access. And we all play a role in cybersecurity in protecting our data, our infrastructure, and our way of life. So as we looked back over the years, we've seen that there have been multiple very substantial breaches that have caused a lot of problems for not just private business, but also for government. And we've learned something from each breach, which is wonderful, but we need to keep learning more and we need to keep doing more. And part of the process of doing more was when FedRAMP was established in 2011 following a government breach. What happened next is that we thought to ourselves, the board of directors at State Ramp, what is the next best way that we can continue to protect our nation at the state and local level, right? SLED organizations, SLTT organizations. And that is how State Ramp was ultimately founded. Next slide.
Can I ask a quick question?
Sure can.
I'm kind of a procurement trade geek. I do a lot of stuff in that area. And it strikes me that FedRAMP is very useful because it gives a common approach to dealing with issues of cybersecurity at the federal level. But it doesn't necessarily break down huge barriers. In some ways, I don't know if you heard my back and forth with Brandon. FedRAMP, there have been people who've been concerned that FedRAMP raises barriers to entry. It strikes me, though, it's kind of the flip situation at the state level. I'm going to put the local to one side for just a second, because it's easier to think about 50 states than it is to think about thousands of city governments. Okay.
Yes,
At the state level, if we don't have something like state ramp, we've got a huge problem, because
that is correct.
all these disparate standards just make it almost impossible to go across the country, for a vendor, for example, to go across the country efficiently, because they're dealing with all these different cybersecurity standards. Is that something you think about at state ramp? Like, oh my gosh, we are the only possible solution to a huge potential, like a massive breach of the Commerce Clause. That we really do want to open up these borders effectively by having something like a common standard.
That is exactly correct. Yes. And I will get a little bit more into that in a couple of slides, but really that is our goal, right? We are a nonprofit. We have members both in the private and the public sector. And the reason for that is we want to ensure that we're promoting best practices across the board in cybersecurity. We want to take into consideration the concerns and the thoughts of our providers, but we also really want to ensure that we're meeting the needs of our governments and that we're protecting information, the information of our citizens adequately. What it allows us to do through State Ramp is to leverage these standardized assessments, right? So you're not trying at a procurement level to compare apples to oranges. You're not trying to compare a SOC to other assessments. You're looking at one singular assessment, NIST 853, which is what FedRAMP is also built off. And we are able then to allow for providers to verify once, serve many. That's a big part of what we say is in our mission. If you click through to the next slide, I can talk a little bit more about why, or what is State Ramp rather.
Can I ask a quick question? Just so we talked about it early in the session with Brandon. He talked about 800 in this standard 853. So in terms of the core standard that State Ramp is built around, help me here, because I'm an old guy. I'm trying to catch up with all the cybersecurity stuff. Is it fair to say that in terms of the core standard, there's really no dispute that State Ramp is using a core standard? Nobody can complain about the standard that's being used, the procedural requirements that the NIST standard calls for. It's the implementation that there might be some dispute about. But in terms of the core standard is a common standard. In fact, it's dictated by the federal government.
That is correct. Yes. Yes, and we're very good partners with FedRAMP and really have worked very hard to build that relationship and to utilize the steps and the things that the roadblocks they've encountered to kind of model what we do and how we move forward. I think the big key thing to realize here is that FedRAMP can be very limiting, and you kind of mentioned that before, because in order to get FedRAMP authorization, you need to have a federal government contract. And somebody brought up the idea of small business earlier. Small business is what helps states run effectively. You can't run your state without small business. The problem is many small businesses are not ever going to get a FedRAMP authorization because they simply are not going to have a federal government contract large enough to justify that. Additionally, with FedRAMP, you're not going to get access to continuous monitoring, which is something that we here at State Ramp do and that we really rely on and believe is super important for state governments because it gives them a window into seeing what's actually happening behind the scenes with their providers and ensuring that they know if there are problems, that they know if there are vulnerabilities, and that they can make informed decisions about risk. So these are ways that, like, State Ramp, while it is built off of that model, and we really do pride ourselves on the fact that we are using that singular standard, we also make sure that it's going to be open and available to more individuals, more businesses, rather than what FedRAMP allows.
I think it's worthwhile emphasizing because, and again, my job as the academic advisor to this overall process is to figure out what I need to say over and over again in the drafting process. And I think the point you just made is incredibly important, which is that state and local governments rely on small business and that they don't, for example, just to say Washington, D.C. Washington, D.C. is across the river from many of the most sophisticated contractors in the universe. Washington, D.C. government doesn't have access to those contractors by and large. The contractors see from a perspective of opportunity cost and in terms of operational challenges, and also even from a perspective of corruption risk. Contractors oftentimes don't cross the river into Washington, D.C. So Washington, D.C., as you put it, could not operate without the small businesses. It's an essential part the success of the city, or some might say it's a pseudo state government. That's a really important point, and it means that the posture that the MPC has to take is one that leaves the pathway open for these small businesses, which are so essential.
That's correct. Yes. And we really try to support that here at State Ramp. We really think that there's such an innate value in that. And I'll talk a little bit more from the procurement side, how we feel this actually helps small businesses actually compete at the same level as some of these large businesses that have been known to just kind of scoop in and they can do all of the, all of the assessments, all the things, and therefore seem more appealing. We can just talk very high level. If we move on to the next slide, this is just a quick map of where we're at today. We are a startup. We've only been around since 2020. We've made substantial strides since then. We have 356 individual government members, 141 provider members. Anybody on this call that works in a government capacity that wants to learn more is welcome to join as a member. It's free. It'll get you access to all of the information we have on our site. And if you have questions, you can certainly reach out to me. Next slide. You can see that we are expanding across the country. We have a lot of states that are coming on board, a lot of locals that are coming on board. We have a few higher education institutions as well. We just implemented, this isn't even actually the most updated. We just fully implemented in the state of Colorado, which is wonderful. As you mentioned before, we have partnerships with Arizona. We have partnerships with Texas. Brandon, I believe, is the one who mentioned that, it really from a business perspective works very well that we've created these partnerships because it is much more prudent and practical for a business who intends to do business in multiple states to achieve a state ramp certification rather than a Tex ramp certification. Tex ramp is only going to be something that works for them within the boundaries of Texas. So if they have the opportunity and Texas is going to recognize that, we have seen a lot of influx in our membership based upon the partnership now that we have with Texas, which has been wonderful. And there is some difficulties that you see and come across in codifying these types of laws at a state level. There could be difficulties just in terms of implementation and how much lift and how much bandwidth it takes to truly do this at an operational level. But also, again, you're really limiting things for the providers because it's yet another assessment that they have to go get and yet another step that they have to take in order to do business in your state, which can be cost prohibitive and can just sometimes be a challenge for them. Next slide.
Yeah, one of the peculiarities of American procurement, Jessica, is that we, both at the state level and at the federal level, nobody thinks about the fact that the government procurement is actually a huge chunk of the GDP. So just for instance, the federal government procurement is the size of the state of Michigan. That's how large it is in terms of the economic weight of it. In Europe, in contrast, they think about this all the time. They think about how do we set up procurement systems so there's better integration. I think without state ramp, because everybody can follow the NIST standards, but the genius of state ramp is how you implement the NIST standards. Without
Correct.
state ramp or something like state ramp, we've got a Commerce Clause crisis.
Yes, we really do try in this case to look at state ramp allowing for states to move into an oversight role rather than having to be, doing every step of process risk management and assessment and trying to keep track of every single cloud provider they use and how it touches, because these things are you don't realize how many ways that you have access points. Like, for example, like even your HVAC systems nowadays are technically something that state ramp you'd probably want included in your contracts. And that's just not something many IT people are considering, and that definitely not many procurement people are considering, because if it doesn't come directly through IT, they're not necessarily aware that that's an issue. I'm not going to spend a lot of time on these slides, but I did want to include these just for the participants so that they can see how state ramp is structured. We do have a board of directors. We try on all of our board and our committees to have these be a good mix of people with different experiences. Our steering committee, or I'm sorry, our standing committees, which is the next slide, you'll see the majority of these individuals are government related. So yes, we do have now a provider focused committee, which has been very helpful. We get a lot of input from them, but we really want to ensure that our committees lean government heavy, because our goal at the end of the day is to ensure that we're meeting the needs of our governments and that we are making sure that whatever we do, whatever standards we accept, whatever products we approve, that these are things that the governments that are on our committees are looking at and saying, yes, this is the direction we want to go, and that this is what's going to do best to protect our governments and our citizens.
I
That's-
just heard
go ahead.
you jump in for a second, because I found this a fascinating part about your website, Jessica. Because I didn't understand this before. So the standing committees actually serve a procedural role. So for
Yes.
example, the appeals committee is what hears appeals from, let's say, a provider that feels like it should have been approved and it wasn't. So
That's correct.
it actually has an administrative function, which I think is a fascinating aspect of this organization. Really, it makes it a much more dynamic and active organization because you're actually engaged in this interaction with the IT and the governance community.
Yes, we really are. I mean, like our standards and technical committee, for example, just recently approved all of the Rev 5 baselines, and FedRAMP moved to their Rev 5 baselines, and we now have been able to move to ours as well. So they're regularly looking at these things. We're iterating. We're saying what's working, what's not working. How are we ensuring that we're meeting that high standard all the time, and that we are doing our best to continue to grow where we need to grow and build out new ideas that actually help us do work at the speed of government, right? You'll see later, we're going to talk a little bit about our snapshot program, and that's actually something that came out of those kinds of iterations. So yes, it's a really wonderfully dynamic organization.
So just to clarify for the audience, when you talk about Rev 4 versus Rev 5, you're talking about going from, it's the NIST standard 853, going from the revision 4 to revision 5.
That is correct, yes.
Just so the audience understands how integrated this all is, on the NIST website, the analysis that was done on the difference between Rev 4 and Rev 5 was actually done for the Director of National Intelligence. It was done by MITRE Corp. So there's an integration here with integration with intelligence imperatives at the top level, the federal level, and now you're integrating that back down through the state ramp process.
That is correct. And then the next slide is just our committee charters for anybody that is interested. I know I kind of like to geek out a little bit and sometimes go look at these things. So if anybody is interested, that's where you'll find those. So then next slide. The big question that of course everybody wants to ask is why state ramp? So really, we look at this as a tool that fills that gap. And I think that Professor Eakins was talking about this earlier. We really try to eliminate the silos that we see between your CPO, your CISO, your CIO. We all know that can happen in government, but it can make it really difficult, especially at the procurement level, when you're trying to put contracts in place that meet the needs of those of your government that are tasked with ensuring that they've mitigated risk. So what we've been able to do here is take this complex review process that has diverse compliance frameworks and just really shift it down so that you're comparing apples to apples. It allows you to have a more clear picture into what are your security concerns, why are those your security concerns, and then how do you address them. Right now, with the way that a lot of states operate, is just self-assessment, checking a box on your procurement documents that say that you meet whatever the requirements are of your entity's standard cyber policy. Obviously, there's not a lot of check that can be done to that to verify that, in fact, they are meeting those, short of your staff who has limited bandwidth going through and assessing all of that. And so state ramp really takes that piece out and no longer makes that a requirement. Next slide. So how state ramp works, it's a little bit different, right? So because we have two arms, we have our public sector piece and then we have our service provider piece. Our service providers are what are supporting state ramp, keeping the lights on, helping us to do business. Public sector, this is a free service. It is free to all governments and it is intended to remain that way forever. We do not need to add something else for you all to have to procure. And the goal here, really, our mission is to get everybody into a much better cyber maturity. So what we do is we share procurement templates. We share our best practices with public sector organizations. We assist with incorporating our statement compliance standards into your documents. In some instances, we actually do take state documents and we rewrite them to include those and send them back, because we really try to act where we can, kind of a staff hog to help you do these things. In some situations, we have a state where they're like, nope, I want to do it myself, but I'd love to see your templates, or I'd love for you to review them when we're done. And that's fine too. We really just try to do whatever we can to be a full support for that entity. We provide vendor and stakeholder education, ongoing education within the procurements department or within the CIO's office. And then we continue through that ConMon to offer ongoing insight into the vendor security posture. For the providers themselves, we offer a couple of different things. With Snapshot, the PMO supports that snapshot review. We kind of call that a credit score for cyber posture. It's a gap analysis. And we go through, there's some consulting that takes place on a monthly basis with quarterly snapshots to be able to see, are you progressing? Are you moving down the line and increasing your cyber maturity as a vendor? It also allows for us to create a path for them to state ramp ready or state ramp authorized. And it coordinates that continuous monitoring portal and helps us manage the membership and benefits that go along with that. Do you have any questions about this, Chris?
Yeah, I've got a couple. So we have from Henry Reck's former student of ours. He says, what are the volunteer procedures? In case I missed your message in the beginning, how does one volunteer to participate in state ramp?
So in terms of volunteering, I don't know that we necessarily have any volunteer opportunities per se. Right now, we are actually in open nominations. So if you are a government member and you wish to look at what we have open as far as our committees are concerned, we are always looking for people to join those committees. And there will be a link at the end of this presentation that can help take you there. The other thing that I had mentioned previously is that it's just a really great resource to go ahead and join if you are with the government as an individual member, and you get all the benefits that those government members get, and you can see a lot of the information that we kind of keep on the back end of our website.
So the question I had to do with your snapshot. So I was fascinated about the snapshot because the snapshot is an opportunity for a provider to find out where it stands and where it has to go, what it has to do. But it also, the provider is actually allowed to share that snapshot with customers, with government customers. And what it really highlights is, as you said this at the beginning, this is really a risk assessment. This is an ongoing risk assessment. And in some cases, customers may be willing to take on, if it's a really good product, but it's not quite mature yet, they may be willing to take on a certain amount of risk. And that's a really important insight, because and Jessica, this is where, being a lifetime procurement geek, and a procurement law professor, what we're stuck in the procurement law world is a series of administrative processes, oftentimes that have been inherited from things that are hundreds of years old in English law. Questions like who has standing to bring a big challenge, things like that, to bring a big protest. So we have all these old administrative clunky processes when we're really trying to do a 21st century risk assessment. And I think it's worthwhile what the state ramp snapshot brings to the fore is this is about risk, and we have to have contracting officials, CIOs, chief information security officers making ongoing risk assessments. And when you view it in those terms, the integration and the cooperation between those three classes of officers makes so much more sense, because it's about risk. It's not about a clunky yes/no administrative process. It's about risk.
Yes, that is exactly right. And actually, we're going to move into that here and talking a little bit about the security framework. So that's actually a great segue. So I'm not going to get into the weeds on this because I am not the person who should be telling you all of the technical details. But what I will say to everybody listening today is, if you have any questions about this, if you want to get into the weeds and into the technical details, we have people that will be happy to get on a call with you and walk you through that. So please do not hesitate to reach out to me, email me. I will get on a call with you and an individual from our tech team, and we can do that. But just at a very high level, we kind of referenced this earlier, our state ramp baselines, they're a minimum standard. It's the criteria that was built based on the NIST 853 Rev 4, just like FedRAMP. We have adopted our Rev 5 baselines. Our goal is also to then map frameworks for CGIS, IRS frameworks, the MARS, MMIS, HIPAA. We really want to, wherever possible, to cross things over so that we can make this as easy on providers, but also as easy on our government entities as is possible. Ultimately, this process or this the state 153 will get you, based on what controls are in place, to either a state ramp ready, a state ramp authorized, or a state ramp provisional security status at the end of the day. Next slide.
Yeah, just quickly here, in terms of things that we did not discuss before, when Jacob and Brandon talked about various lines of potential liability, the False Claims Act, for example, or HIPAA, what they did not talk about is potential third-party tort liability. And what's interesting about this is, as this area matured, and a vendor will be able to say, oh, I followed the government standards, I followed state ramp. The government contractor defense against third-party tort liability will come into focus. You say, oh, this is the government standard, I followed it, therefore I should. And Brandon and Jacob talked about a little bit that you start to have safe harbors built into state laws based on following certain standards. That really is a replication. In this domain, it's a replication of the government contractor defense. I followed the state standards, I followed the government standards, I therefore shouldn't have third-party tort liability if something goes wrong.
So this is where we lead into that security snapshot and the progressing security snapshot program. What happened after we launched is we realized that state ramp ready and state ramp authorized are imperative, and they're absolutely necessary, and we need people to get there, right? We need our providers to get there. But it takes a while for them to do that, because these are in-depth assessments that have to be done. They have to go through the 3PAO audit process. They then have to run through the PMO. It is a lengthy process. So obviously government can't stop business to wait on that to happen. Also, from the perspective of procurement, we want to make sure that we're not limiting business and limiting competition. So how do we do that? Well, this is ultimately where we came up with this kind of pre-ready assessment. And that's our state ramp security snapshot and our state ramp progressing security snapshot program. Next slide. So the progressing security snapshot is actually what we recommend as best practice. Generally, what we suggest people do is procurement would work into their solicitation that an initial state ramp security snapshot is required. This allows for the procurement team to utilize a weighted score and make this very objective. The cost of a single snapshot is very low. It's a very low barrier to entry. It has a 3-week maximum turnaround time, so we can get them back very quickly for the purposes of solicitations. And what you pay depends on your revenue. Much of the way that we've structured our programming here is what you pay is based on your revenue, so that we are not asking the small mom and pop shops to try and compete at the same level as, Microsoft or AWS. We then recommend for best practice that what you would do is, once you have that score, once you have ultimately finished your solicitation process, that your contract would build into it that the individual, the company, is required to maintain on the progressing security snapshot program throughout the life of the agreement, up to a set period of time that you as the entity has all the power to decide how long that is to get to ready or authorized. Next slide. What this ultimately is, right? We talked briefly about this before, as the progressing security snapshot program is like a credit score. It's a gap assessment and score. Independent verification and validation by our state ramp PMO. So what does that mean? What it means is it's not just self-attestation. It means you're not just having your provider come in and say, yep, I do all these things. Instead, they have to sit down with our PMO office. They have to show the PMO artifacts that prove that they do the things that are on this, the criteria that are on this list. The criteria is based off of that NIST 853. And ultimately, they're going to be given a score. With the progressing snapshot, they're going to then get to repeat that snapshot on a quarterly basis so that you can see that they're moving in the right direction. That's the key. We want to have a noticeable effect on the maturity of the product that you're using. Ultimately, they'll get monthly consultative calls with our PMO security team to see where they can be moving the needle and the impact that they can be making. And the benefit here is that they can provision that access to you as a government to say, you can look at my notes, you can look at my snapshots, you can see that I'm moving the needle. And again, this is where our monthly subscription is based on revenue. So this allows an entity to know that they have a contract and then build in the cost that they may experience to that contract. So is there going to be some pass-through cost? Yes, and we do try to share that with governments because we know that they want to know that. The question that has to be at the end of the day, what's more important, a small pass-through cost to accommodate this level of risk management and you moving into an oversight role as opposed to an assessor role? Or would you, rather have a product that maybe you don't get a good look at what they're actually doing and what their actual risks are? You have any questions there, Chris?
You just got me. I think we solved the huge problem. So a whopping problem if in the procurement world overall is when you have contractor qualification information, how do you share that between governments? I think what you've done, because what's built into the snapshot is what's buried in the terms is that the vendor shares it with the customer and can share it with other customers if they want, but it's the
Yes.
vendor's call. And this may ultimately be the solution because we won't be able to reach some sort of coherent decision on how effectively can governments share information with each other regarding contractor qualification. The answer may be if you can simplify and streamline the information enough so that it's the transaction cost of actually sharing that information makes sense, then you can leave it up to the contractors to make the decision. Yeah, I'll share it with this other government because I do want to work with this other government. I'm willing to take the risk of giving the information to this other government to help them do a risk assessment. It's a very interesting solution to what really is a very deep problem in internationally in the public procurement realm.
The benefit too is the initial snapshot we say is good for a 12-month period. So it allows for that provider to submit it to any solicitation they want for that single fee over a 12-month period. And then much like you said, they could ultimately share their progressing snapshot with multiple entities, multiple states. So it really does defer that cost out across the board. We've also heard from some procurement professionals that they are less worried about protests at that point because they have an apples to apples comparison that's very objective and they're very easily able to score versus just handing off a stack of assessments to their, security office and saying, review these and then score them. And then you don't really know exactly what they're looking to score. Are they scoring things the same? Are they scoring the same types of documents? Or are you comparing, different frameworks? So we have heard that it helps in that regard as well. And then once you get to, we talked a little bit about the progressing notes and whatnot with Snapshot, but once you get to a status of ready or authorized, ultimately, then you go through continuous monitoring and you have to report to us a set number or a required set of information, and you will provide that every month. And we're going to have an escalation process where if something stands out, if you haven't reported what you're supposed to, if maybe you've had a change in ownership, we're going to send out an escalation to any government that's been provisioned access so that they know that that's been changed. The government still has the ability to go in on their own whenever they'd like and look themselves, but they don't have to because we're taking the proactive effort to alert them when there are issues or things that we think they need to be able to be made aware of. Additionally, they're going to have to submit an annual audit every year to continue to maintain that status to show that they're still up to the proper standards. And so then we come to our authorized product list. So everything that has a ready or authorized status is going to be on our authorized product list. We also have a section on this list beneath the authorized products that shows people or products rather that are progressing through our program and where they are. We will now also be adding a section to this. I believe it was just approved by our Standards and Technical Committee at our last meeting, a section on here that will show anybody that is enrolled in the Progressing Snapshot program as well. And that will help our friends in Texas, as well as any other government that really wants to rely on utilizing products that are already engaged in that process. And you're welcome to, of course, go there, take a look at that list. There's also some template resources that might be helpful to people on this call. And any questions about those, you're welcome to reach out. The other thing we do here, which I don't have a slide on, but I thought I would just casually mention it, is for those entities that already have a product that has FedRAMP certification of some kind, we do have a fast track for that process. And so it allows for them to submit all the same documents that they submitted to FedRAMP to StateRAMP. So they do not have to redo their 3PAO assessment. They do not have to redo all of their documents, their materials. They can just submit that same package. It allows for us to then review that in a much shorter period of time. And then it allows them to get on the same cycle for their continuous monitoring reporting so that they can report the same thing to FedRAMP that they're reporting to us. But the benefit obviously with this is that you as a government would have access to that where you would not have access to those continuous monitoring documents through FedRAMP.
Can I ask you just this? So we got a question. It's a hard question, and I'm going to try to answer it if it's okay, Jessica. So the question is: state ramp program sounds great, but what are the antitrust issues that arise in having a dominant third-party provider? And I think part of the answer to that is that, well, so what state ramp is doing is implementing a commonly recognized standard, the NIST standard. And the state ramp could become dominant if states start to say, drop clauses in and say, you have to be state ramp authorized. But this is the important but, the regulatory structure, the surrounding regulatory structure is itself maturing. And if you look at precedents from Europe, they're actually ahead of us in terms of this type of openness in standards in the contracting process. You can't just say state ramp. You have to say, what has to be implied is state ramp or equivalent. It has to be that state ramp or equivalent. We've had that in sole source law for forever, and now it's just coming into the realm of technical standards. So even if you don't say or equivalent, it has to be read into it, state ramp or equivalent. So while state ramp may be called out in the solicitation, other providers that are implementing what really are common NIST standards, these are nationally recognized standards, could move into the same space as state ramp. And in assessing the competitive posture of state ramp, whether or not it holds a dominant position, you have to take that into account, that anybody could slide in alongside of state ramp, because by definition, a clause that calls out state ramp has to allow the equivalent as well. Have I answered the question right?
You have, and I do want to say, like, from our perspective at this point, there just simply is no one else in the space that does what we do, that really does align with FedRAMP in that same way, and that opens up continuous monitoring to everyone across the board. What we have seen people putting in their solicitations, like I'll use Colorado standards, for example, is they accept FedRAMP or they accept state ramp. Those are the assessments that they will accept. And I would say, like, if there were an equivalent, then they probably would add that to their standard. It's just that right now there isn't an equivalent. And it doesn't mean we won't always be that way, but for now, that is where we are. I will say too, there is a lot of interest and discussion of, I had kind of mentioned this earlier, of working frameworks across different niche markets, for example. So like high trust, we're in the process of seeing if there's a way to pilot some fast track programming for high trust, because again, really our goal is to make this as easy as we can on all of our governments, but also all of our providers, because having there be a more unified framework that people can use actually makes the cost of doing business go down, and actually makes the ability for them to do business more easeful. And so that's really our goal. From a procurement perspective, it's actually perfect. We land right here on this slide, which is, how do we make this work, right? How does this get incorporated? And so the key first thing, obviously, is identifying if state ramp would apply. And the thing that I would encourage everybody is to think outside the box, because it will apply more often than you think that it will apply. Anytime that your programs, your products are touching your data in some way, there is a chance that you're going to want state ramp involved in that. So just think outside the box here. If you have questions, we stand ready to help. Call us up, ask us. We really do want to be, like I said earlier, an extension of your team. Then you need to determine what your state ramp impact level is, because again, much like FedRAMP, we have low plus, moderate, and then we follow FedRAMP high. And then you're going to need to incorporate language into your solicitation and contract documents. And what that looks like is truly up to the entity. We do have best practice. We do have those templates we're happy to share. Some draft language we're happy to share. We're actually close partners with NASPO. They are a strategic partner of State Ramp. We are in the process right now of working on a joint task force between State Ramp and NASPO for the sole purpose of getting the right heads in the room to really refine what we're calling our procurement toolkit, so that we can really help across the nation get some uniformity where we can, and have a common language that we're using. And then once you get to that evaluation award section, you're going to review that snapshot if you've chosen to do that. You're going to confirm if they're enrolled in progressing snapshot. You're going to make sure that you have your requirements in the contract documents that say how long it will be until they are meet ready or authorized. And then through your contract administration period, you're literally just going to be doing the due diligence of checking in with the State Rep Continuous Monitoring Portal to see that they're doing what they said they were going to be doing. And that, like I said, you can take kind of a back seat to that and allow us to do it and just give you the proactive notices. Or if you want to get in the weeds, we welcome you. You have access to that portal, and we're happy for you to take a spin and look around in there. Next slide.
Just quickly on this one, Jessica, those two people say the incorporating language and reviewing that and the evaluation award, what are your third and fourth steps here? That what's really important to emphasize is that these are done in the context of a fundamental shift in the way that states and local governments now are doing procurement. They're using competitive negotiations much more often. They're
Yes.
not, it's not a set low, it's not a low bid, seal bid, it's competitive.
Correct.
So this period here between your third and fourth steps, that's a period of extensive back and forth between the government and the individual vendors through competitive negotiations. So you have much more of an opportunity to work out things that, for example, of equivalence, because of that much more thoroughgoing in dialogue between the two sides, because of the change in competitive and the shift to competitive negotiations.
Yes, that is true. So this just goes over again, our implementation team really is there to support every government entity, whether they're state, local, higher ed, K through 12, that we're seeing a lot there as well. With the procurement piece, the InfoSec piece, helping through onboarding to get you access to that portal, handling, like I said earlier, whether that's actually writing up the solicitation contract language into your documents for you, or just providing you with our best practice language, vendor outreach. We try to take as much as we can off your plate. We recognize that probably, all government entities are typically running short-staffed, right? But the turnover rate and the lack of staff for both procurement and for our CIO office and our information security teams are so high that we want to do whatever we can to make this process as seamless and easy for you, so that you don't feel like it's yet another hoop you have to jump through just to get up to speed to a place where you're ensuring that your data and your citizens' data is safe. Next slide.
Just a comment here. So as we're going down the MPC path here to revise the Model Procurement Code, we've always tried to look, what's the salient thing that we have to deal with? What's the most important thing we have to deal with? It turns out it's exactly what you just identified. It's a personnel shortage. So one of the reporters on our effort is Natalie. She's the procurement officer for Cook County. Cook County would be our 26th state if it were a state. It's that large. And say, well, how many procurement lawyers do they have? One. They have one procurement lawyer for the entire Cook County. There's a huge population. So as we think about the Model Procurement Code reform, finding ways to reduce personnel stress is so important. In fact, it turns out to be probably the most important consideration as we're remolding this law, because if we set up processes that are people intensive, we're in deep trouble.
That is very well said. Yes. And I really feel like State Rep tries to keep that in mind on a regular basis in our actions. And when we move forward, is how do we really ensure that we are not risking our abilities to move forward and be protected because we're handicapping ourselves by making these processes too complicated for anybody to actually execute. This is just kind of what we discussed earlier. You're welcome to join our mission. If you want to become an individual member, you're welcome to do that. You can, if you have any questions for me, you can email me directly at jessica@stateramp.org, or you can email my team at get@stateramp.org. There are just a lot of benefits to getting involved, and we would love to have you involved. Even if it's just to learn more, we're happy to be there for you and help you in that journey. And then our next slide is just a list of helpful links. If you want to look at our templates or what governments we have participating, look at some of our program pages, whatever you find on there. I do think we'll be revamping our website soon, but for now, it's fairly easy to navigate. But if you can't find something, like I said, just email me and I'm happy to help.
It's so much classier than my blog. Speaking of which, so we're gonna wrap up here. We'll say that this video is going to be available on publicprocurementinternational.com. publicprocurementinternational.com tomorrow. And it's publicprocurementinternational.com/MPC-reform is the program page for this program that we've had over the last 4 sessions. We're going to have a meeting tomorrow of the steering committee for the MPC reform. We'll be talking about this webinar series. And next week, the public contract law section is part of the ABA annual meeting. We'll be moving forward in the MPC reform. And this foundation, Jessica, then Brandon and Jacob, this foundation that you've helped us lay for the reform of the Model Procurement Code, I think is a very, very important step forward, and I'm very, very grateful. Thanks for doing a great job, and have a great evening, Jessica and Brandon and
Thank
Jacob.
you so much.
Thank you. Bye-bye.